This is a video of my testimony in the Tennessee House of Representatives Judiciary Committee regarding pending legislation that will oppress our rights as citizens to challenge laws that are unconstitutional. Without the ability to challenge unconstitutional laws directly, something very dangerous happens. Government can pass unconstitutional statutes, Constitution be damned, and those laws remain in force until someone is prosecuted under them. Rights exist only after arrest, after punishment, after oppression. The Constitution becomes a defense rather than a shield. For example, under this legislation, if it passes, if another new law is passed that prohibits speaking or writing on some topic, making it a misdemeanor crime subject to 30 days in jail, we can't challenge that law as a violation of free speech until we are first harmed by the new law, until after we've been arrested, maybe forced to post bail and spend thousands on hiring an attorney to defend us in court. So watch my testimony.
Gentry, would you like to go first? You got 2 minutes. I'm over here.
So my name is John Gentry. Members of the committee, the Constitution is supposed to protect people before they're harmed by government, not after. And this bill reverses that principle. And what Chairman Farmer is talking about, harm, that's called the standing doctrine that the courts use. And the standing doctrine is not law. The standing doctrine is a judge-developed legal doctrine. And so when the legislature says, well, we're gonna let judges go ahead and make the law, that you have to suffer harm before you can bring a lawsuit. And I think that's wrong with the standing doctrine. It's used very often by the courts to wrongfully dismiss cases. Under the Tennessee Constitution, Article 1, Section 1, the people have a right to reform government. Is a government who has enacted unconstitutional law in need of reform? Of course it is. And does Article 1, Section 1 say there must be harm? It does not. Article 1, Section 2, the doctrine of non-resistance is absurd. It is absurd of citizens to not resist arbitrary abuse of power with government enacting law that is unconstitutional. Under Article 1, Section 17, suits may be brought against the state. It is a constitutional right under the Constitution of this state. Article 1, Section 23, citizens have a right to apply to those invested with the powers of government for proper purpose by address or remonstrance. Does Section 23 say we have to suffer harm before we can apply to government? It does not. Does Section 23 say we can apply to those invested with the powers of government? Yes. Is a court invested with the powers of government? Yes, it is. So this
Mr.
law
Gentry.
itself...
Sir, your 2 minutes are up, sir. Thank you. All right.
So notice I don't even get to finish my sentence. Instead, I'm subjected to a hard microphone shutdown. Typically, I'm given 3 to 4 minutes to address a committee. I didn't hear the chairperson say I was only allowed 2 minutes this time. And it's really hard to make a legal argument in only 2 minutes, especially when you're cut off mid-sentence. Now, this next gentleman is from the Attorney General's office. Unlike me, he is not subjected to a time limit. He gets to talk as long as he wants to, and he doesn't get cut off like I do. This is true in every committee hearing. State officials get as long as they want. Citizens, only a couple minutes. Does that make us second-class citizens? I think so. Now, I'm not including his entire testimony, just a clip of the most ridiculous statement that the so-called standing doctrine stems from the Constitution, which I'll speak to in Q&A.
My name is Matt Rice. I'm with the Attorney General's office. I'm the Solicitor General of Tennessee. Thank you all for having me. Just a couple of points of clarification with respect to my friend's comments on the other side. My friend seems to be taking issue with the standing doctrine. The standing doctrine stems from the Tennessee Constitution. Legislation can't change the Tennessee Constitution. So this bill has absolutely nothing to do with standing. Standing stems from the Constitution.
Okay, so the gentleman from the Attorney General's office, he spoke quite a bit more, but not once did he address the core of my testimony, which is one, we have a right to reform government, and a government enacting unconstitutional law must be reformed, and we have a right to apply to government for redress or proper purpose, and neither of those provisions require that the people must first suffer harm before asserting those rights. So now, listen to me in Q&A.
Representative Johnson, you're recognized.
Thank you, Madam Chair. So to Mr. Gentry, in the description of this bill right underneath, it says, as introduced, removes the right of a cause of action for any affected person who seeks declaratory and injunctive relief in any action brought regarding the legality or constitutionality of a state governmental action. When I see something that says removes the right to a cause of action, I find that concerning. Is that something that concerns you with this bill as well?
Absolutely, Representative Johnson, you should be concerned. So seeking declaratory judgment is asking a court to declare a statute as unconstitutional. And so they're saying the citizens can't challenge that. And that goes against the principle that we have a right to reform government and we have a right to apply to government. It doesn't say that we have to suffer harm. And the gentleman for the state here has said that the Tennessee Constitution includes the standing doctrine. I actually authored a book explaining the Tennessee Constitution focused on the Declaration of Rights, but in other parts of it, I have not seen that. And I would like to see how the Constitution is interpreted to say that the standing doctrine is part of our Constitution, because I don't think that it is. That it should raise serious concerns that we can't bring a cause of action. You know, already, and I say it with hesitation, but quite frankly, these houses make a mockery of the right of citizens to petition the legislature. We should be able to come to the legislative houses and address the legislative body and say, we think this law is unconstitutional. And so that constitutional right that we have that is fundamental to a government Republican in character, we don't have that right to petition the legislature and address the body and complain that something is unconstitutional. And so now it seems that we want to take away the opportunity to even go to the courts. And so now we have to wait until somebody suffers, until somebody is harmed, that they get prosecuted. Maybe they have to place bail before they can challenge it. And then when they do challenge the constitutionality of a law in court, I believe it is Tennessee Code and TCA 2914-107B, that if you challenge a statute as unconstitutional, you have to notice the Office of Attorney General. And if you fail to notice the AG, the court says, well, you didn't follow the rule, you didn't notice the Attorney General, and so this issue is moot. We're not even going to address the question as to the constitution of this statute that you may be prosecuted under or may have suffered harm for. And that is not an appealable issue. So if you don't notice the AG when you challenge the constitution of a statute, you are done. That issue will not be addressed at the appellate level or at the trial court level. And so there are procedural shields in addition to the fact that you know, standing is not law, it's a legal doctrine, and that we have a right to reform government and we have a right to apply to government, including the courts. And so this bill itself, in my strong opinion, is in violation of our state constitution because it oppresses the right to apply to those invested with the powers of government, and it oppresses the right to reform government. And it oppresses the right to bring suits against the state in Section 17. Thank you for that question, Representative Johnson.
Okay, so here I was quite clear in my answering that question that the bill under consideration is itself unconstitutional because it oppresses the right of the people to reform government, and it oppresses the right of the people to apply to the courts and the right of the people to bring suit against the state. Now, after my testimony, there was a lot of back and forth between members of the committee, both for and against the bill. But not once did a single member address my argument that we have a right to reform government, and this legislation oppresses that right. And not once did a single member address my argument that we have a right to apply to those invested with the powers of government and seek court ruling that a state law is unconstitutional. They didn't address my argument because they can't defeat my argument. And they can't defeat my argument, so they just ignore it as if I never said it. Now, I do want to highlight two members who spoke in committee, Democrat Gloria Johnson opposing and Republican Representative William Lamberth favoring lessening the rights of the people. So take a listen to Representative Johnson's statements.
Representative Johnson, you're recognized.
Thank you, Madam Chair. This is an odd one as well as my colleague just spoke about. I've heard from all sides of the aisle, but I can tell you that I got a lot of emails on this issue. And some people will tell you I'm a Republican or I'm a Democrat or I'm an independent. But I don't think I got a single person that wanted a yes vote on this bill. They were all very concerned about it. And regardless of the party, everyone who emailed me on this legislation were against it. And so I'm going to have to vote with my constituents on this bill. Thank you.
As Representative Johnson said, this bill is opposed by the people, Republicans and Democrats. Clearly, this bill is opposed by the people, and those members advancing this in committee are not representative of the people. They are representative of protecting government enacting unconstitutional law. And I know for a fact that many thousands of grassroots Republicans oppose this bill, and I appreciate a Democrat speaking to that fact. Now, next here is William Lamberth, Representative William Lamberth, whose comments I think are probably just flat out false information, or at best, they fail to place blame where it belongs. So take a listen to Representative Lamberth.
And so now every frivolous lawsuit that anybody can dream up is being filed against the state with millions of dollars in discovery.
Okay, so what Representative Lamberth said, and I quote, is these frivolous lawsuits are costing the state millions of dollars. If that's true, and I don't think it is, if there are frivolous lawsuits, then it's a failure of judges and attorneys to follow ethical rules that are established for attorneys by the Tennessee Supreme Court, and they're allowing violation of rules of civil procedure. So Rule 11 in the Tennessee Rules of Civil Procedure, it says that an attorney filing a lawsuit is making a claim that it is based in law, that it has merit, and that it's not based on frivolous arguments. So they're making a firm representation to the court. Now, under the rules of professional responsibility, an attorney who knows of another attorney who's engaging in misconduct shall report them. And so what they're supposed to do, if there is a frivolous lawsuit, then they're supposed to report them to the Board of Professional Responsibility so they can be disciplined. And in the Board of Judicial Conduct, it says the same thing, that if a judge knows of an attorney engaging in misconduct, they shall report them. So this is the breakdown. It's not frivolous lawsuits if there are any. Now, when he's saying it's costing the state millions of dollars in discovery and defending the state against these lawsuits, you don't get discovery until you go to a scheduling conference, and you don't go to a scheduling conference unless you first addressed a motion to dismiss because a lawsuit is frivolous, or a motion for summary judgment because they aren't able to state a valid claim or what other principle for summary judgment. So that's the breakdown that's in here.
All right, Madam Clerk, open the board. We're going to vote on House Bill 1971 as amended, moving forward to calendar and rules. Anyone wish to change their vote? Madam Clerk, count the vote, please.
Madam Chair, you have 11 ayes, 9 noes, and 0 present not voting.
All right, we have House Bill 1971 passes. It's moving forward to calendar and rules.
Now, the last thing I'll say in here is Sumner County and the people of, including parts of Goodlettsville, Hendersonville, and Millersville, I need you to put me in an office so I can debate these guys and rebuke false arguments like the one made by Representative Lambert. I need you to put me in there so that I can speak as an equal and defend the Constitution and defend the people of this state and my district. I can do it to some extent, out in the gallery as a citizen defending the Constitution, but I really need to be in there to effectively defend the Constitution and the rights of the people of this state. So I hope you will vote John Gentry for District 45, Tennessee House of Representatives. Thanks for taking time. Have a good day.